welcome. You're watching Plain Speak and I'm Rehatul Siddiqui. The school uniform, to my knowledge, was essentially to have a uniformity, as the word suggests, and a level playing field for children coming in to get educated, where there is no demarcation on the basis of class and social stature, where the rich don't look richer and the privileged ones do not go ahead and surpass the poorer, and the impressionable minds coming from lesser privilege don't feel any inferior in front of their peers. How then did this debate on uniform become that of religious markers? The matter before the Supreme Court today was about the contentions that were raised against the Karnataka High Court order that upheld a government circular by which hijab was banned in classrooms. What came out of it was a split verdict, with one of the judges upholding the March 15th High Court order validating the ban, and the other one setting aside the High Court ruling and calling wearing of the apparel a matter of choice. With the two-judge bench divided in its view, the matter has now been directed to be placed before the Chief Justice of India, UU Lalit, for appropriate directions. But the question of choice, the right to education, when placed before that of state control, is it not impinging upon the constitutional promise of dignity and fraternity? The test on what is an essential religious practice has always been a problematic one. While many would question the preconceived ideas on morality, if we look at morality on the basis of court arguments and judgments, even the law doesn't seem to be settled on this. And the hijab isn't a full veil. And the prohibited ground on the basis of which we can restrict religious freedom, our public interest, health and morality, none of it is impacted if a few girls choose to wear the hijab. Why then is it coming in the way of education, is what we are asking.
There is no end to the hangama over hijab. 7 months after the Karnataka High Court upheld a government order banning hijab in educational institutes, petitions challenging the hijab ban led to a split verdict in the Supreme Court. While one judge, Justice Hemant Gupta, dismissed the petitions, the other judge, Justice Sudhanshu Dhulia, was of a differing opinion. He said asking girls to take off their hijab is an attack on their privacy and dignity. He said that under the Indian constitutional scheme, wearing a hijab should be simply a matter of choice. It may or may not be a matter of essential religious practice, but it is still a matter of conscience, belief and expression. He said the government order and restrictions on hijab goes against value of fraternity and human dignity. The case has also to be seen in the perspective of the challenges already faced by a girl child in reaching her school. And are we making the life of a girl child any better by denying her education merely because she wears a hijab?
प्राइम मिनिस्टर से सबसे पहले मैं ये अपील करना चाहूँगी कि वो हमारे एजुकेशन को हम पे छोड़ दें और हमारे हिजाब को उसमें कोई कॉन्फ्लिक्ट ना बने हमारा हिजाब, क्योंकि देखिए हिजाब हमारा राइट है और हमें इसको फॉलो करना है.
The matter will now be placed before the Chief Justice of India, who will constitute a larger bench to hear the case afresh. Till then, the hijab ban remains in place.
I expect the judgment, definitely it will be in favor of Karnataka's rules and act. Whatever the rules and regulations which have been followed now will be valid till the judgment of the higher bench comes.
But many in the opposition are hoping for a more favourable order from a larger bench.
जो हाई कोर्ट का जजमेंट था मेरी राय में, it was bad in law, bad in terms of its contents, or it had misused Quranic commentaries and translation. This has serious ramifications, should not have been allowed.
But at a time when women worldwide are demanding not to wear the hijab, can individual choice override institutional autonomy?
So let's now take a look at how this hijab debate stands when it comes to the court. What happened in the Karnataka High Court and how did the Supreme Court choose to respond to it? So Karnataka High Court in fact ruled that the Holy Quran does not mandate the wearing of hijab, while there was a split verdict that came out of the Supreme Court where one judge upheld the ban, the other one was in favor of removing the ban on hijab. Then again, the Karnataka High Court said that wearing hijab may have to do with culture and not religion, essentially saying that it was not part of the essential religious practice. While the verdict coming out of the Supreme Court, one judge ended up saying that wearing hijab is a matter of belief and expression, essentially also a matter of choice. Also, Karnataka High Court said that the petitioners miserably failed to prove it as an essential religious practice, and hence that ruling that came out of the High Court, where today one of the judges of the Supreme Court mentioned that wearing hijab should be a matter of choice, only a matter of choice. It's totally to do with an individual person on whether or not she chooses to wear it. Karnataka High Court went on to say that the issue has been blown out of proportion in the middle of the term. Once again, that big question that we are also talking about, the derailment of education. Then again, the Supreme Court today said where one of the judges also questioned the move to deny education because of hijab. Essentially, both the courts were making similar points, and that's something that we as well are asking. Karnataka High Court again said that unseen hands are at work to engineer disharmony. We all saw the kind of protests and violence that erupted in the state of Karnataka after this entire debate was in court as well. The split verdict that came out of the Supreme Court, where one of the judges said that removing hijab is an attack on privacy and dignity, so that right to privacy and also to practice and propagate one's religion was something that was brought in the court as well. Karnataka High Court, while it spoke about going ahead and disrupting the harmony in the state, the Supreme Court spoke about how it is essential to the right to privacy also. So those articles, whether it is 25 or 19, 21, also invoked by the court. Now let's take a look at this split verdict that we are talking about that came out of the Supreme Court of the country. While one judge ended up talking about how hijab is a matter of choice, the other one differed and said that it is not essential to the religious practice when it comes to Islam. So Justice Sudhanshu Dhulia said the quashing of the government order of February 5th and removing restrictions is something that is essential. While on the other hand, Justice Hemant Gupta said that there is divergence of opinion and hence things have not been able to be decided in this court hearing. Then again, Justice Dhulia said that venturing into essential religious practice is not needed at the moment. Right now, that is not the debate, is what the argument of Mr. Justice Dhulia was. While on the other hand, Justice Gupta said hijab is not part of essential religious practice under Islam, clearly putting it out there. Now, the other argument made by Justice Dhulia was that it is a matter of choice, nothing more, nothing less. So essentially, it goes down to choice is what Justice Dhulia said. Justice Gupta goes on to say that all appeals are dismissed, hijab not essential religious practice. That putting it out there when it comes to ERP. Justice Dhulia again talks about education of the girl child, which is very important, and it is a matter of individual choice. Once again, reiterating the word choice. Justice Gupta, on the other hand, speaks about management in taking calls on uniform and not violative of fundamental rights. So if the school or the educational institute decides on what that educational institute feels should be the uniform, that is not violative of any kind of fundamental right, is what Justice Gupta ruled. Now, the question that we are asking when it comes to this hijab verdict, it is a divided bench of the Supreme Court, but who's derailing the right to education of these girls? Let me first take this across to my colleague Ananya, who's been tracking all the developments that came out of the Supreme Court today. Ananya, you've got the copy of the order. Essentially, if you break it down for our viewers, what does it say?
Well, definitely. This is a split verdict that is coming from Justice Hemant Gupta and Justice Sudhanshu Dhulia. Justice Sudhanshu Dhulia is basically the dissenting judge into this particular case. He has allowed all the appeals that have been there in the Karnataka High Court, while Justice Hemant Gupta has actually dismissed these appeals that have been filed against the Karnataka High Court's order. So, Justice Dhulia says that it is like a ticket for these small girls to go to school, because they are there. Some of them live in so conservative families that if they are not wearing a hijab, they are not allowed to go out, and that's the reason why hijab is ultimately also a choice, and in fact, attack on the and any kind of a restriction in hijab would be in fact attack on the right to dignity or and the right to privacy of that particular woman and the particular girl. In fact, on the other hand, what Justice Hemant Gupta says is that though we are a secular country, we are into a secular country, and in fact only because of that we cannot allow hijab inside educational institution because it would be like allowing one particular community with their religious symbols. What about the other ones, is what Justice Hemant Gupta says. He also goes on to say that these appeals have no merit and and are to be dismissed. And in fact, he also went on to say that the Karnataka government had clear powers to actually issue that government order and go into restricting hijab inside educational institutions. But what is very, very crucial to note is today's judgment of Justice Sudhanshu Dhulia, because he's talked how hijab is actually a ticket for some girls to in fact go to school, because it's very challenging for girls, especially in the rural areas, in order to go to schools. Already it's a challenge, and then if they're not wearing a hijab, that becomes another problem to them. And that's the reason why hijab shall be upheld, and it's a matter of choice, not a ERP, not anything else, but a matter of choice that these girls want to do.
Right, Ananya, stay on. We have got some breaking news on this very story that we are tracking. Now we are told that the All India Bar Association has requested the Chief Justice of India that the hijab issue should be referred to a larger bench of minimum 5 judges that includes one Muslim judge before the Supreme Court after this split verdict has come out of the apex court of the country. Ananya, more details please.
The AIBA, that is the All India Bar Association, has actually written down a letter, in fact, requesting that a 5 judges bench is a constitution bench that we call generally hears this matter, because remember the ratio in 5 judges bench is of a 3:2 ratio, which hears that particular matter, and if at all there's a dissent, then also it's either a 3:2. There's no question of dissent that happens into this particular judgment, because there is a ratio of 3:2 that remains, and also a special request has been made into this particular case by the AIBA that a Muslim judge should also be there on that particular bench, so that there is in fact there comes to be another aspect of religion can also be taken care of. So that's why the 5 judges bench has actually been sought by the All India Bar Association. However, it's just a letter that has been written by the AIBA, but we'll have to wait for the Chief Justice of India. And a very, very crucial point that we have to wait is for whether this matter would be now placed before a larger bench before Justice U. Lalit's retirement or post his retirement, because then the dynamics would also be changing in the Indian judiciary, as new CJI Justice D.Y. Chandrachud would be taking over, and the matter, he would then become the master of the roster.
Absolutely. Ananya, thank you so much for all those details. In fact, let me open this to my guests who are joining me on the broadcast, but before that, once again reiterating the big question that we are asking today. Now, joining me on the broadcast on this big debate is Arnav A. Bagalwadi, who's an advocate and petitioner for the people who were talking about how hijab should be allowed inside the campuses. Brinda Adige, who's a social activist, also joins me. Also, Rahul Ishwar, author and activist, joining me on the broadcast, and also joining me, senior advocate Faizan Mustafa. And also with me is Maulana Masood Ul Hasan Khazmi, who's an Islamic scholar. Thank you so much for being a part of this conversation. You know, let me take this across to you, Mr. Mustafa. Whether hijab making that cut, whether it is something that is an essential religious practice, has been much talked about. What is your take on that?
No, the question is not whether hijab is an essential religious practice. The question is whether Karnataka High Court should have gone into this question of essential religious practice. Because once the Sabrimala review has been accepted by the court, and the court is seized with this question, whether the court should act as clergy and decide purely religious questions. Now, Justice Dhulia very clearly says in this judgment, quoting even Babri Masjid judgment, that the court should not take up theological questions. We are a constitution court, and our judges are trained in the common law tradition. And therefore, I personally feel, and Justice Dhulia is right when he says that the petitioners are also responsible for the mess in which they are. Ideally, they should not have made any argument based on Islam that hijab is an essential religious practice. They should have simply argued that it is their choice, it is part of their privacy, it is part of their freedom of speech and expression. And since they were before a constitutional court looking at the constitutional provisions would have decided whether they uphold these rights or whether they go with the Karnataka High Court judgment, very controversial, with Justice Dhulia entirely disagrees, that the moment somebody walks into a school, then he loses his fundamental rights. Comparing classrooms with the military camps, I think, or the jails was unwarranted. And that way, I feel that Justice Dhulia's judgment on this is a sound pronouncement. So the question is not, whether hijab is an essential or non-essential. It is a question of choice. Okay. If in Iran, their clergy and government would impose hijab, we would oppose it because the girls in Iran have to make a choice. If in India somebody imposes hijab on them, the girls would be free to argue that we are not going to concede this, whatever we feel like. So ultimately,
okay. All right, Mr. Mustafa, let me take this across to Arnab. Yeah, all right. Let me take this across to Arnab, and I'll come to you, Rahul. I know you're raising your hand. Just respond to this, Arnab. Do you think that the argument that was put before the Karnataka High Court, claiming hijab to be an ERP, an essential religious practice, was something that actually started this entire, case against the people who are choosing to back hijab in the wrong way?
No, see, that was one of the prayers that were made in one of the petitions. And of course, to say that it is an essential religious practice was probably long or short. And because at the same time, had we, had enough material to place on record, yes, this is an essential religious practice, a lot of other things would have followed because, for example, if you were to take the turban, that has the constitutional sanctity of being an essential religious practice. So once that happens, automatically, you have that, protection with the constitution. So maybe that prayer is still a long shot, but at the same time, it still remains a choice of the students. And by no means, when they enter the campus, do they lose such a fundamental right? And can such a right be, lost? Merely based on an executive order or a notification by the government? That's the real question today.
All right. Rahul Ishwar, the same thing happened in the Sabrimala judgment. Your response?
Yeah, as a petitioner in Sabrimala case and also as a protester who spent weeks in jail, see, we always maintain that court should not interfere in any religious or spiritual practice on principle. But here the question is different. Here the core question, as you rightly pointed out in the introduction, is whether individual right is higher or whether the institutional right is higher. Second, also a supplementary question is, if the individual right is higher, is it an essential religious practice? Holy Quran rightly points out modesty. Prophet Muhammad sallallahu alaihi wasallam rightly points out modesty. Gandhiji in 1947 points out that Quran points out about modesty, not about any particular dress code. So here the core question is whether any dress code is inscribed in Holy Quran or, can it be interpreted along with Hadith? That's another question. So Supreme Court or any court will have to decide on law whether any particular individual has a right overriding that of institution. For example, we can wear, or anybody can wear hijab at any point of time. But when you go to an institution, can you wear it is the question. And one last line. Justice Fatima Bibi, the first female judge of Supreme Court, may it be from any community, Hindu, Christian or Muslim, whenever she used to come to court, she always used to adhere to the court's dress code. And whenever she used to go outside, she used to cover her head and go in the holy Islamic way. So can there be any balance like this that can also be sought? But at the end of the day, education of Muslim girls is important. Hindu-Muslim unity or communal harmony is important. Right now, as an Indian, I welcome this verdict because it points out that two opinions can exist. Even two learned judges have two different opinions. So both opinions are respectable. We should, without hatred to anyone, engage with these opinions and also look at the legality of it.
Okay. It is still a matter of choice. That is essentially what is being underlined over here. Maulana Kazmi, yes, you wanted to make a point. Please go ahead, sir.
Yes. As Dr. Faizan Mustafa earlier also mentioned, this is not the question of religious practice. This is the question of constitutionally provided right of autonomy to individuals with respect to wearing or eating or professing any religion of any choice. On the one hand, We allowed students of one community to go to school with religious symbols like turban, like bindi, and we also allowed recitation of Gita in government-run schools. On the other hand, we are depriving Muslim girls from their right of choice and hijab. So this is not right. It is not equal. It is not with respect,
even then, it is essential to first determine what falls under the contours of religion. That's important for the courts to bring in and break any kind of law. So, what is the point that you are making? You are saying it is a part of essential religious practice, or do you differ in your argument here?
No. There are both issues are there. Number one. When we go to school, when Muslim girls go to school, saying that we have our choice, we have our constitutionally provided choice. So the school deprive them and send them away. Then they ask, why you have allowed the turban? Why you have allowed the bindi? They say this is their practice, essential religious practice. So we say the so is in Islam also. In Islam, the hijab is also essential religious practice.
Okay.
So this is the both. This matter starts with right of personal choice and stop on the essential practice, essential religious practice. Yeah,
okay, let me take this back to Mr. Mustafa, then I'll come to you, Brinda. Mr. Mustafa, you have been a scholar when it comes to Islamic studies also, and also constitutional studies. Do you think the argument that Maulana Qasmi is making is the correct one, or it is to do with interpretation and also an individual's choice, because it is a matter of religion which is purely personal?
You see, Justice Dhulia makes an interesting point where he says that the court should not bother about theological questions, because he very clearly says, because on theological questions, you will always have different points of view. And the court, quoting his words, does not have the authority to uphold any one particular point of view. So definitely there is a debate whether hijab is an essential or is not an essential Islamic practice. But ideally, in this case, we should not go in that debate.
Okay, all right. Brinda, matter of choice. Once again, upheld by the court today. At least one aspect did come out like that. Your views?
Yes, what Justice Dhulia said is reaffirmation of the right of choice to the woman to wear what she chooses, where she thinks that is her modesty or that is her dignity and probably her safety too. Why is it that somebody else, and here the state is deciding that this is a religious garb? We do not have to go into that. Like the justice pointed out and the eminent panelist before me pointed out, theology is not required to be argued and discussed by the court and make decisions. What the court has decided is a constitutional right of choice that this woman can make. It is her right. She can make that choice as long as she's not harming anybody. Now, left with this argument of uniform also to a large extent gets defined and redefined differently. How many times have we pulled up anybody saying your turban is an essential religious practice and these religious practice symbols cannot be worn inside my classroom? We have never said that. We've respected them. And like the other panelists pointed out, it's a bindi, a sacred thread, a chain with a cross on it or a medal on it. Fine, those are all your choices where you don't hinder anybody. And it has continued with the uniform. Nobody said anything about it for this many years. Today, we are raising an issue and largely men and the theocratic state, is becoming theocratic to say, you can't wear it because it is a religious symbol and we are trying to promote equality. We are trying to promote progressiveness. This is regressive. Absolutely agreed. Parda is as regressive as the hijab. And nobody said that our ex-president was regressive simply because she covered her head in the parliament, outside the country, anywhere that she chose. She was comfortable doing it. And we all respect it. That is it. Respect that choice.
You know, very interesting point that Brinda is making, and it slightly will digress the debate. I'll still go ahead and, allow it. Rahul, it's a tragedy that there is just one lady on the panel today. We're talking about a woman's right to choose, and there are so many men talking about and giving us differing opinions. Why do you think this debate really started? Earlier, this point that Brinda was making, never seemed to have been a problem. Why this political play? Why this matter before the court and now before the apex court?
2 points. One, I'm a Hindu activist, but I don't have any dishonesty in conceding the point that there was a power struggle in Karnataka. There were some communal tensions. There were hardliners of both community fighting with each other. So it resulted in many of these things. Is a reality that we should all be mindful of. That's one thing. Absolutely, yes. But second point, yes, Pratibha Patel ji used to cover her head. There were a lot of people used to cover their head. But the question here is different. Nobody is saying that hijab should not be worn. Nobody is saying that any particular dress should not be worn. The only question is inside an institution. A particular institution can definitely allow hijab. A particular institution can definitely allow any kind of dress. It is up to the institution. So the legal and constitutional point here is not the hijab, not the individual right, but whether an institutional right is lower than the individual right. This is the only question. That's the reason why one judge called the Bija Emmanuel case, the famous national anthem case, and so many things come into play. So here the core question is individual right or institutional right. And constitutionally, we can only elect for institutional right because our institution has certain rights, just like the individuals. But I totally agree with the sentiments. Our Muslim brothers, Muslim sisters should come forward. They should study more. They should get educated. But we should also find a balance in this particular thing. That's the reason why, without compromising the institutional right, which is very important because an institution is run by people, a group, and that institution also has some rights. So the only question is they can wear any kind of dress anywhere and everywhere in the world. But in an institution, when a dress code is there, then come the question. One more thing. If that institution decides, let there be hijab, let there be any other dress, then it is also okay. So the institution's rights should be protected. Along with that, I hope Supreme Court will come and blend and balance the individual right and also give some kind of space for
you
our
also
Muslim
quoted the Bijoy Emmanuel judgment that was actually referred to in the Supreme Court, and that essentially was talking about how if students do not choose to sing the national anthem, they're more than okay to do that. They can't be branded anti-national for that. Arnav wants to make a point. Yes, Arnav, please go ahead.
I'm glad my panelists had in fact brought this out. So the Bijoy Emmanuel case talks about consciously held religious faith. And here it talks about two people of the entire school who decided not to sing the national anthem. But what is the important aspect here is that they did not choose to disrupt or show any disrespect to the national anthem. And I don't see where wearing the hijab in the classroom caters to any disruption in the classroom. I'm very happy that Justice Dhulia has opined in the having this opined in the way he has, insofar as bringing the aspect of inclusivity into the constitution. And in fact, with this dissenting opinion, he in fact has reposed faith in those of the minority, by allowing them to see that yes, this constitution that we have that in fact allows for inclusivity, allows for heterogeneity, is very much present and still breathing.
Mr. Mustafa, I'll come to you. Why this debate now? Why suddenly has, when I started this entire broadcast and how I wanted to actually go ahead with this very, very, sensitive story. When I, in my school days, talk about the uniform, things were very different. How suddenly, in just about so many years, things have changed to the religious aspect and religious demarcations. School uniforms were not meant to cover or accentuate somebody's religious choice, whether it is the pagdi or the hijab or even a tilak to an extent. Why has it got down to this?
Yes.
No, suddenly, religion is all over. In a secular India, one is surprised to see that young girls are more keen to put on hijab. When I was a student, then no Muslim girl in my class was having hijab. So many times what happens when you are pushed to wall, you assert your identity.
Yeah.
And in any case, there is a huge surge of religiosity. And this religiosity, I am sorry to say, Ishwar is a good friend and I respect him a lot, is absolutely devoid of spirituality. And that is something very, very sad. But the whole question which is there in this case, it's not a question of institutions' right, so to say. What the Karnataka High Court has held, that when you are in school, you do not have a fundamental right, you have a derivative right. So can we now say that the moment I enter the school gate, I lose all my fundamental rights? Now, if we concede that power to any institution, it would be a bad day for a modern liberal democracy which is committed to liberty and choice and privacy. That is important to me. But I am surprised that girls of modern time are making a choice to have a hijab. I have been saying it and writing it. I'm really shocked that so many of them are interested in hijab.
Maulana Kazmi, we had a reference of Iran. Of course, this very topical must be spoken about, but not in the Indian context. Let's talk about countries who have banned hijab, who have made hijab mandatory, and there are countries where hijab is a choice. So even the Islamic world is clearly divided on whether hijab is an essential religious practice, which is the argument that you are going ahead and making. How do you see it in that context?
No, we are not governed by Saudi Arabia or by Turkey or by other countries. We are governed by our constitution and we admire our constitution. Whatever religious practice our Muslims practice in our country is under the constitutional framework, under the purview of the constitution, and whatever the religious activity is done of the extra constitution, law and law, he or she should face
अभी तो आपने
the
बोला
law,
कि ये
and they
essential
are
religious
facing.
practice है, constitutional right is a different aspect.
जी.
तो मैं आपसे ये पूछ रही हूँ
No,
कि
no,
अगर
no,
हिजाब
constitution
essential
has also
religious
given-
practice है, तो ये different countries, Islamic nations, why are they divided on their opinion on what should it be for the ladies, whether they should go ahead and wear it, whether it is allowed, not allowed? Why is it so differing?
No, this is the matter of interpretation of the divine book. This is the matter of interpretation of the divine book. In Turkey, they may be thinking otherwise, but we Islamic scholars, all the Islamic scholars, including Turkey is one, they are of the one view that hijab is essential religious practice in Islamic faith. This is the fact. This is the go any Islamic. But if you don't have your Islamic background, you are not Islamic scholar, you can say anything. And that is what is happening in Turkey.
Okay. Brinda Adige, what is happening in Iran? Should it offer any sort of context to what should be
Now,
there
Iran,
in
we
our country?
We condemn Iran.
Okay.
We condemn Iran because it is suppressing the women who are demanding for their own choice.
All right.
And so is in our country also. These Muslim girls also demanding their right of choice in shape of
All right. So
hijab.
let me take that question to Brinda, Mr. Maulana Kazmi. Brinda, do you think the context of Iran can be referred to when it comes to our own country? Do you think that is a good comparison that can be made?
No, the only context that we can compare Iran with India is the choice the women in Iran are making not to wear the hijab. And that choice, again, the theocratic state like Iran is realizing that women are standing up to tell the state, you don't dictate terms to us based on religion or based on whatever powers that they might hold. And that is a choice we want to ask. And I do not think at any point of time we should compare ourselves with Iran, because we are a far more developed nation. We are far more enlightened. And I think we need to hold that very strongly. vis-a-vis institutional rule over an individual's right, can it be ever bigger than the constitution? Can the institutional rule be bigger than the constitution to subjugate that individual which has got guarantees from the constitution? Never. It cannot be. It cannot be. We cannot talk of an institutional rule that says this is what I will do, irrespective of what your constitutional rights and guarantees might be. That cannot be done. Because here, like we are continuously mentioning, if the hijab hinders, hurts, harms another student, no child should wear it. No student should wear it. But if it is not harming anybody, it is just reaffirming this woman or this child, this student, you can now come to school, come to college and avail education. I do not think anybody has a right to tell so. I don't believe in the theological arguments that are happening about whether hijab is important, essential, not essential. I don't think I will want to venture into that at all. What we want to ask ourselves is this girl coming, has access to education? If she wears the hijab, does it hurt me? It doesn't hurt me. Let her access
the fact that it's a very, very important point, and this is something that Justice Dhulia also made.
When I wear a bangle or a sacred thread.
Yes, absolutely. So this is an argument, and this is the point that Justice Dhulia also put forth. Arnav, I'd like you to take this. The fact that many of these girls are coming from less privileged backgrounds. And it's clearly mentioned there in the order copy that we managed to access, where Justice Dhulia goes on to say that many of them even finish their household chores to go ahead and come to school to get educated. Are we not denying them their right to education by imposing that ban? Because that is part of their, whether it is conditioning, whether it is growing up, whether it is their culture, it is totally their right to education as well that needs to reign supreme here.
Absolutely, and I feel that, somewhere that has been lost in the garb of, looking at whether, to wear a hijab or not. We are missing the main point that these girls, first of all, to access education, if you're from the rural background, it's very hard. And now we have girls who, in fact, I'm not sure if you're are privy to the fact that some of them have such, huge ambitions. Some of them wants to become a pilot. One of them wants to become a doctor. And these are ambitions that at the end of the day will help in, taking our country forward. And, so it's by no means, by all means, rather, this ban of hijab is definitely trammeling on their right, and specifically their right to secular education, which needs to be looked at. Because at the end of the day, our constitution is a document of trust. And as Justice Dhulia also says, it's a document of trust, and the minority reposes their trust in the majority. And it's for the majority to take care of this minority. And it's important that we look at the aspect of education, and more so of these girls who would otherwise fall in the minority. So definitely, yes.
Right. Mr. Mustafa, why is religion occupying such a central aspect when it comes to education is also the big question. Also the elephant in the room that needs to be addressed. So why don't you go ahead?
You see, the politicians are making use of religion. The societies are getting polarized. The idioms which are used in election campaigns and in other public meetings have a lot to do with religion. It's very, very easy, to use a religious card to win elections. And that's why I feel that if we really want our country to be progressive and modern and liberal, then ideally the religion should be relegated to the private square. It should be relegated to homes, confined. In fact, in the Constituent Assembly debates, it was suggested that in Article 21, we should add this word privately, that you will have a right to profess and practice and, propagate your religion privately and not in the public square. I'm as an academic, I'm really sad to see that we all the time are talking about religion.
Absolutely. Rahul, yes, you wanted to make a point. The fact that, that's essentially what this entire premise of this debate was. Here we are talking about how all this should not derail education. Education which is required for everybody, especially the girls from many sections of the society, especially the weaker ones. Why should religion be allowed to derail that education, or probably that entire talk of religion as is understood by the masses?
Across spectrum, whether we are right or left or any party, there are some consensus in this issue. One, as your speaker brilliantly put it, religiosity is less important. Spirituality or the inner core and ethics are more important. Second, yes, female education should be sacrosanct. We should assist every community girls to come forward. But the point of divergence that will come in the Supreme Court later too, whether this is an essential practice of religion covered under Article 25 and 26. Second, institutional rights versus individual rights. This is going to be the debate that's going to come. And third, where our Muslim brothers and sisters, if asked, will be able to prove whether this is an essential practice. Because we have even Islamic nations like Egypt's president earlier even mocking hijab, saying that Muslim Brotherhood wants me to cover up all hijab. That's very available in net. So there is an international debate going on in Muslim community itself, whether modesty is important or whether any particular dress code is important. But at the end of the day, we need to have unity. We need no hatred. We need intellectual discussion, not communal clashes. And we need informed discussion and mutual respect. I believe everyone will agree to that point, because on ground it translates into communal hatred. On ground it translates into Hindu-Muslim hatred. We should take this discussion in a refined, intellectual, constitutional, scholastic manner without any hatred on ground. And I believe Karnataka and all the great Kannadigas won't go to that tension kind of a mode again, or rather than only debate it intellectually. Because I was in Karnataka many times, there were on ground many tensions. Hopefully those kind of period is over. The unrest, pot boiling is over. Let us keep our intellectual differences apart. But no, let us not have any hatred on ground, and let us not go ahead and abuse or vilify any girl who is coming in any dress.
Absolutely. Thank you so much. I'd like to thank all my panelists, and let's end this on a high and aspirational note. At least that is something that we can look at, an ideal society where that assertion to, or probably having to assert what they choose to wear, should not be there, and that resistance also should not be there. There should be an open and secular society where everybody is allowed to practice what they choose to and also to wear what they choose to. We leave it at that, and slipping into a very, very short break at the moment. And we told that we're getting some breaking news on the broadcast. Let's quickly take a look at that. We are told that the National Commission for Women has taken on Gopal Italia now, and they have released a statement, and this is what it reads. Right from the beginning, Mr. Italia lied to the Commission. Firstly, he was responding to NCW's questions in Hindi and English, but suddenly, when he had no answers to the questions, he tried to evade them by refusing to speak in either of the languages and insisting that he knew only Gujarati. Later, he was found to be interacting with the media in just Hindi. My colleague Ananya, who has more details on this, is joining me on the broadcast. Ananya, a statement, of course, does it put Mr. Italia in the dock? What does it say?
Well, definitely it puts Mr. Gopal Italia in dock, because remember that this issue has been cropping up, and the National Commission for Women had actually taken so much cognizance of his statement. And now, since the questioning had started and NCW actually had issued notice to ask him to appear before it, and he came today with a crowd of around 100 to 150 people of the Aam Aadmi Party at this commission office. In fact, he the NCW says that at the beginning of the questioning, he was answering questions in Hindi and English, but then when tough questions were actually asked, the factual questions were asked, he said that he does not know any other language but Gujarati, and was evading the questions that are being asked by the National Commission for Women. So a very, very crucial aspect is that the NCW has the powers to issue summons against Mr. Gopal Italia, and we just saw how FIR was about to be registered against him. So the controversy is cropping up, and with these statements, I think the NCW might push in for some action in this particular case.
Are we getting any word from the Aam Aadmi Party, Ananya, since through the day they were quick to respond to how this is, in the run-up to the Gujarat elections, and if there is a targeting of Aam Aadmi Party leaders that is happening? Would you be able to actually assess that for our viewers, if at all there is a response from the Aam Aadmi Party?
Well, it's been very, very soon that this
press release actually came up, and the whole NCW had told about this particular incident and the particular behavior of Mr. Gopal Italia. So in the time to come, in the matter of time, we will get to see reactions from the Aam Aadmi Party, and we'll see as to whether they would defend his stance that he was there or not.
All right, Ananya, thank you so much for joining us on the broadcast. Of course, the statement coming out by the NCW claiming certain lies by Mr. Gopal Italia, claiming that he doesn't even know the language, whether it is Hindi or English, is something that is going to make this debate further into something that is going to be on the grounds of interesting. We'll see how the BJP choose to respond to this, and if at all there is a word by the Aam Aadmi Party. Slipping into a very, very short break and coming right back with more.